the second case on this morning's docket. That is case number 112883, State of Kansas v. Samuel Harris.
May it please the court, I'm Reed Nelson. I'm representing Mr. Harris in this petition. I would like to request 2 minutes for rebuttal to Chief Justice.
2 minutes is granted.
Thank you. And the question is, how did the case get to this court? And the answer is, Mr. Harris was tried in Emporia for a number of crimes, and he was convicted ultimately of robbery, kidnapping, and criminal threat. The jury acquitted him of battery. We appealed that to the Court of Appeals. Primarily, the issues have to do with the kidnapping. The Court of Appeals affirmed the conviction. We petitioned for review, and this court has the case. First issue, I'd like to actually cover 3 issues. I'll try to get to all 3. The first issue that I'd like to cover is that the kidnapping in this case was merely incidental to the robbery that took place and the criminal threats that took place. It's a very important question for our appellate courts when this comes up, because to a jury, the way that the PIC instructions read, almost all standstill robberies are going to be found to be kidnappings. And the defense's hands are tied, right? Because almost all of them, the person's restrained, at least temporarily, and the crime is committed. So the defense has very little with that. The jury does not have what this court has, which is the law, that the kidnapping, if it is only part of the robbery, that that has to be vacated. And that's
where's the line in your mind between the kidnapping and the restraint? And you said that every robbery would then almost necessitate or could necessitate a kidnapping charge. Where's the line? Clearly there's some line somewhere. Where would you draw that?
Well, this court,
for the restraint. And
I agree with what the court in Buggs said way back. And this court, by and large, our appellate courts have held pretty well to that, in my opinion, which is that when these things occur in, like as part of a robbery, in our case, in an apartment or a house, this court has said, well, when somebody is bound, that now is not a normal part of a robbery, and we're going to allow a kidnapping when they're bound or put in a closet and held there in these kind of situations.
How about when the defendant says, I won't let you put your clothes on because I don't want you to run outside and escape?
Right.
That seems to be confinement to me.
Well, it's not allowing her to get help, which is a temporary restraint, or not a temporary restraint, that's an unlawful restraint. That's a false imprisonment under common law. Not letting somebody go out and get help is a unlawful restraint, and that is an appropriate conviction of unlawful restraint. But it doesn't amount to the clear line that this court and the Court of Appeals has drawn, that when somebody is bound and gagged, which is extra, that is a frightening extra experience beyond a normal robbery.
so it's a physical act, you would say, the bounding and the gagging, as opposed to whatever trauma or turmoil or kind of circumstance that this took place over 2 hours, didn't it?
It's a physical act that begins to amount to a real harm that's definite, that occurs to the victim, that makes it appropriate to attach a level 3 felony to that. I mean, this is the problem. When we have things occurring during a robbery and the prosecution charges a kidnapping, a level 3 kidnapping, we advise our clients, you've got to plead guilty to whatever they charge. They don't care about the kidnapping often. They don't care about it. They charge it because they can. And it won't get straightened out until this court sees it. And we go tell our clients, they say, well, I want to take this to trial. We say, you cannot take this to trial because you can't take a risk on a level 3 kidnapping, which the jury will convict you of under the PIC. So it's so important for this court to draw a clear line so that all the parties are on notice of what a kidnapping is, and it ought to really mean something. It ought to mean a level 3 felony. In this case, the real harm were his criminal threats. He threatened to kill her, which she at various times did or didn't take seriously, but that was the serious harm. The robbery was a serious harm. He apparently, the jury found, took $700. But what happens in these cases is the less serious harm, these movements that had no meaning. The holding of her, which she participated in because she was trying to delay him. I mean, he wanted the money and to get out of there. But the holding was partly due to her trying to distract him, offering him sex and things. So, point being that I think that it is so important for this court to draw a very clear line, which it has been doing, in my view, so that counsel know when they read the case that, this can get reversed on appeal if they go for this kidnapping. We can advise our clients try the case. Someday we might be able to get this reversed on appeal because the Kansas Supreme Court has been clear about this. But if it's fuzzy, if some movement from a room to another room might work, then, we fold in the tent. And even though that is not the main crime, that's not the main harm, it prevents a trial. It's something that should be tried.
So do I understand then your position is the distinction between a criminal restraint and a kidnapping is the physical act of binding, or?
Correct. Under this court's case law, under Buggs, well, I'm not sure Buggs exactly addressed that. This court has said binding, putting somebody in that kind of a situation can convert a robbery, and now you can also add that as a kidnapping. And
So had she been clothed and he forced her to take her clothes off, would that be a kidnapping?
No, I wouldn't say that it would be, because
It has to be the physical act of binding.
I would say so, because I understand that keeping her clothes off, not letting her put those clothes back on, prevents her, discourages her from trying to get help. I understand that. That's not a kidnapping. This court has said that preventing somebody during a robbery from getting help, that's not a kidnapping. That's part of a robbery. You have that case that you decided, Kemp, I think, where somebody held somebody against the wall with a crowbar and said, you can't leave while the house was robbed. And then they left. And this court very appropriately said, that isn't going to turn into a level 3 kidnapping. The robbery was the real harm. Well, that's very similar to here. I would hold tight to a clear rule for counsel on the bench that restraint of not letting somebody get help is not going to be converted to a kidnapping. Otherwise, all standstill robberies are kidnappings. People are not allowed to leave.
Is there a temporal distinction, though? Because there it was a restraint while the physical taking was occurring. Here we've got 2 hours of restraint.
This
and I
case,
understand you're saying
right,
part of
this
that was
case-
her problem, but still, it's 2 hours of her not being allowed to have her freedom of movement.
well, discouraging that, yes, I understand discouraging that. And you understood that my argument on that point is that this is a domestic case, partly also, and unfortunately, it's a messy affair. I think he wanted to. He didn't intend to be trying to commit this robbery by holding her for 2 hours. That was not his intent. His intent was to get the money and get out, right? She wanted to delay that. So I'm not saying in any way that this is her fault. I'm saying that in terms of holding, this is a messier situation. This isn't somebody who was bound and gagged for 2 hours. It's a different deal. So
Why aren't all those just arguments to be made to the jury based on the elements in the
That's
instruction?
an excellent question, Your Honor. These should be allowed to be made to a jury. I hope someday the PIC instruction can be modified to allow the arguments that are so factually intensive for this court and the Court of Appeals to be made to a jury, because the defense has nothing in it in terms of being able to argue that the kidnapping was merely incidental to the robbery. Why doesn't the jury get to decide that? Until it does,
Why,
this court has...
what's prohibiting that argument now?
The PIC instruction
Well-
simply says, are they held?
But couldn't the defense attorney ask for a different instruction and make the argument? I mean, then we'd be up on appeal at least on a different issue, whether the district court correctly instructed the jury.
I agree. And I don't have that. I do not have that. I can't say that the jury should have made this, because I'm just saying my only reason for pointing this out is that as it stands right now, without that PIC instruction being changed, this court has an extremely important role in defining kidnapping for the bar and the bench. And again, 216 months, 20 years that he got for the kidnapping, as opposed to a criminal restraint, as opposed to a level 5 robbery. And the kidnapping was not, I submit, not the major harm. So let me, unless there are more questions about that issue, I'm happy to move to my
Seeing
next.
none, please proceed.
I'll briefly cover the second two issues, which are related, which is that the object of the kidnapping, which was given to the jury in the instructions as any crime, should have specified that the intent was that he commit robbery. If that was the intended crime that the state's theory rested on, I'm not sure it was, but so that is clear error, just as the charge was clear error in the same way.
I don't understand that, because in the closing argument, the prosecutor said, we're focused on the robbery, we're focused on the money.
The prosecutor argued robbery.
I mean,
Yes,
you're,
right.
I mean, I guess the way I'm understanding this issue is that she testified that he took her money and her cell phone, so the cell phone is what you're worried about. And the state is elected in closing and said, we're not talking about the cell phone, we're talking about the money. So why doesn't that fix this? Why isn't that the election that the state makes
Well,
that clears up this
Sorry.
confusion that you're trying to?
I understand. So my understanding, and I hope I'm quoting the record correctly here, my understanding was that the prosecutor's closing argument went to robbery. I don't believe that the prosecutor's argument was tying the robbery into the kidnapping. I would have to check my notes again, but I don't think that they drew that. In fact, defense counsel, and I think really the state's case, was maybe that the kidnapping was because he wouldn't let her flee and get help, and that somehow facilitated his flight, which it didn't. I mean, it didn't facilitate flight. So not allowing her to
The whole
flee.
incident was about flight, though, wasn't it?
I'm sorry?
As you said a moment ago, the entire 2-hour series of events was all about flight, right? As soon as he pushed her and she bruised, I mean, that's the theory, right? He said, I need to get out of here. Where's your money?
Right.
So don't we have lots of evidence about the whole thing being to facilitate his flight?
It has to be holding or moving with the intent to facilitate flight. He wanted to get out of there. He wasn't holding her to facilitate flight. He wanted out. He was holding her obviously to prevent her escaping, but that's not kidnapping. And when I discuss these, I understand that I'm a lawyer up here. It looks like I'm cutting some very fine lines. But upon those fine lines is the difference between a misdemeanor and 216 months.
Well, you said he wanted out. Why didn't he just leave?
He wanted out with her money.
Right.
Yeah, the robbery
and
was
isn't that
facilitated.
very akin to essentially a ransom? I mean, it's like, I'm going to hold you here until I get my money.
Well, she was trying to delay him. She didn't want to tell
But
him where the money was. So he was after, it's more complicated. It's not a
This
straight
level,
ransom.
there's an additional level. The robbery was clearly to facilitate flight, right? I mean, we've certainly got abundant evidence of that. He repeatedly said, I need your money to get out of here. So that he needed the money that he got by robbing her to get out of there.
Well,
And you've got two different issues here. I
defense
think we've got
counsel
a little
didn't agree with that.
confusion. I understand,
yeah.
but that there's plenty of evidence to support the state's theory on that point, that the robbery was to facilitate his flight.
there's,
And I understand if you don't want to give that up.
there's evidence to
today, but
support that. Yes, there
Yes,
is.
there is
But
evidence.
let me clarify something too, just factually. Once he acquired the money, he didn't leave. He continued to hold her for a good period of time while he was making a phone call to get picked up.
Oh, I see. Yeah, I
Waiting on a
why?
friend.
Yeah,
To
that's.
quote Mick Jagger, waiting on a friend. He was waiting on a friend to come fetch him.
I thought he got out of there pretty fast, but
No,
yeah.
I mean,
Well, they stood
no.
by the front door for a while.
Okay, right.
Yeah, no, he still held her while he was waiting, made a phone call and waited. That's not like wanting to leave immediately upon acquiring what he sought to acquire.
All right, all right. I didn't recall exactly how all
Well,
that
you know,
ended.
If I can back you
yeah.
up just a second. I think we got a little confusion between two separate issues in your briefs. You're saying that there was a failure to include what is an essential element of the crime by not specifying robbery in the instruction as the crime that was motivating the kidnapping, right?
That's correct.
Okay, so that's one issue. Then you have these other multiple acts / alternative means issues about sufficiency of proof and whether there should have been a unanimity instruction, et cetera. On the robbery, there were two items taken. I mean, if we just call the money an item and the cell phone an item, but that, I think that's what my colleague was referring to earlier. There was an election by the prosecution of the money is what we're talking about on the robbery, right?
I think so. Yes.
Okay,
I think
and that undercuts your alternative means sufficiency argument, correct?
I agree.
And I looked at the record, the reference is to money, not just a
Correct,
generic robbery
correct.
that might include the cell phone. So there's that specificity.
I agree, Your Honor. On the robbery, I think that they did elect and steer the jury on their closing argument in that.
Any further questions? Thank you, counsel.
Thank you.
Laura Miser, Assistant Lyon County Attorney. In addressing my colleague's arguments as to the kidnapping being incidental to the robbery, I just respectfully disagree, because when we talk about the Buggs case that he relied upon as far as going to requiring binding and that type of confinement, the state would argue that the actions by Mr. Harris in this matter also effectively bound the victim. He bound her by not allowing her to put on her clothing. He bound her to his side pretty much throughout the entirety of the events as he moved her from room to room, kept her with him, bound her by his actions, by physical threats of keeping a pillow that made her concerned if he was going to smother her. And so in looking at that, and counsel's arguments that a kidnapping really has to mean something, the actions really have to mean something, the state would argue Mr. Harris's actions in this case really did mean something to the victim. He was in her apartment for several hours, keeping her confined, controlling her every move, telling her where to sit, keeping her away from the wall that she could have banged on for help from her neighbor. And so in looking at those actions, as well as the arguments about this is just a criminal restraint, it's not just about the actions that determine the difference between criminal restraint and kidnapping, it's also the intent behind those actions. His intent was to rob her. His intent for the actions of restraining her were to get her money. Now, just because she had the wherewithal to try and stall him to a point that she felt comfortable until she felt she was in danger and gave it up, that is irrelevant that she might have prolonged this. His intent was clearly to rob her, to take her money, and he did this by controlling her within the confines of her apartment from room to room and making sure she was essentially bound to him and her actions were bound by what he would allow her to do.
Your point being you can control the victim by other means than duct tape and rope.
Yes. And actually, he did try to get her to help him untangle some electrical cords in order to bind her, but essentially was frustrated in that as well. As to the argument regarding the omission of the specific crime in the instructions that I believe counsel alluded to, an argument in regards to the jury instructions, the state believes that the appellate court's review of the situation and resulting opinion was correct, that it provided the elements, and that in looking at that under a clear error standard, they were appropriate in reaching the no reasonable probability that the outcome would have been different if the crime of robbery had been specifically stated. I know the court had set out an order regarding the Dunn and Ferguson issues, so unless justices have any further questions, I would stand on the Court of Appeals opinions and the briefs and the underlying rationale for that matter.
Let me follow up there.
Yes, sir.
So you're saying that we should not go to Ferguson, we should go to Dunn.
That would be my assessment, yes.
Why?
Because when looking at what Dunn did, it removed the issue of a defective complaint from its specialized status, is how I would characterize it. Because prior to Dunn, Hall looked at the issue of defective complaints differently than it did from other errors. It gave a framework to analyze it differently than other errors.
That launched from the proposition that the complaint was a jurisdictional document.
Yes, and Hall relied upon Minor. So when Dunn essentially overruled Minor, it then removed the Hall framework for how to look at the issue of defective complaints. Ferguson adopted that special framework in how do you review a defective complaint in the guise of an ineffective assistance claim. So in the state's argument is that Dunn simply takes that error back to square one and treats it the same as any other error. And looking at that is, did you raise it below at district court? If you didn't, why should we look it out on appeal? And then on your ineffective claims would be treated the same way as any other ineffective assistance claim is, did you raise it on appeal? If not, why should we look at it here? And if we look at it now, we're going to look at it under Strickland. Did counsel's performance fail? And if it did fail, did it cause prejudice?
Don't we end up at the same sort of place, regardless of whether it's Dunn or Ferguson?
In
Because
this
the
case,
bottom line is the defense counsel testified he wasn't misled, he understood what was going on and adequately prepared. And it seems like Ferguson would have asked those same questions, and we would have done it by using Dunn and then getting over to Strickland. It seems to me.
yes, the state would argue we'd be in exactly the same place, regardless of which framework this particular set of circumstances were analyzed under. The end result is still the same. Mr. Harris was not prejudiced, and the Court of Appeals reached the correct decision in affirming the lower court's holdings.
Does that conclude your presentation?
Unless there are any other questions in regard to that issue, yes.
Any more questions? What are you asking us to do?
Asking you to affirm the appellate court's decisions in affirming the convictions of Mr. Harris, and that the lower court's rulings were appropriate in regards to the ineffective assistance claim.
Very well. Thank you, counsel.
Thank you.
Counsel went through with you the various reasons why she believes that he was essentially bound, that this, what happened here was the equivalent of being bound. And again, I agree. I think being bound is a good bright line that this court could use. But this was a far cry from being bound. she could have left, as she said, she characterized it this way, she could have left when she told him where the money was, right? And she didn't want to do that. She wanted to stall things out. That's a far cry from being bound. If somebody can leave, if they say the magic word, they can leave the closet or have the duct tape come off or whatever it is. So I think that's a far cry. And if something is the equivalent of being bound, if that's what counts as a separate kidnapping, then all standstill robberies, the person is essentially bound because they cannot leave. So that would be not a good rule. So I would ask the court to hold to the bright line of the obvious physical things that happen in these situations. I think that is how the rule ought to go.
Counsel, I wanted to ask you a factual question. It appears that she offered sex to him. What was her purpose in doing that?
To delay him, to distract him. I think that this was all kind of emotional and crazy. My impression is it was sort of an emotional, crazy thing. And that she realized that if she sort of delayed him, that he would kind of change his mind or decide that he didn't want the money after all. And so she was trying to get his mind off the...
Does that in any way indicate that if she was acting or thinking objectively that she thought she was being kidnapped?
No,
She
Your
was
Honor.
willing to offer him sex to end this whole episode?
Yeah, I don't think so. I mean, I think that it showed that she knew that he wasn't completely steadfast about the whole thing. And if she told him where the money was, she knows she admitted that he would have left and it would have ended. So I think that removes it from being essentially bound and places it firmly into the camp of there was a robbery taking place. There were criminal threats, serious criminal threats that she eventually took seriously, I think, enough to give him the money, that were taking place during this time. But this holding, while this was happening, these minor room changes, while these more serious things were happening, don't promote those things up to this level 3. So,
Right.
Counsel, why don't you address the Ferguson-Dunn question that we asked you to be prepared to address?
yes, Your Honor, I agree with opposing counsel the way that I think that they both are an equivalent.
I mean, Ferguson really eliminates the argument you're trying to make.
Correct.
Based on existing law. Dunn adds a new factor. We're going to end up at the same place regardless of which path we take, right?
I agree with that.
Okay, so the defense lawyer says he didn't have a problem. He understood what was going on.
Yeah.
He was adequately prepared, and the district court at the Van Cleve hearing believed the defense lawyer. So how do we do anything with that except it?
The trial doesn't support what defense counsel said at the Van Cleve hearing. He said at the Van Cleve hearing that he understood that the robbery was the intended crime. But the trial doesn't support that because his closing arguments at trial were that the facilitation of flight, facilitating his own flight, was what the theory was that he was addressing. I don't think that this, robbery being the intended crime was how the case was tried. It's not how her testimony rolled out. She was talking about not being able to get to that wall to warn the other people. So for whatever reason, for whatever reason, I don't think that statement that he made at the Van Cleve hearing is supported by what happened at trial. I think that he guessed wrong. In fact, so if you look at that his trial argument, where he goes, it wasn't flight. He wasn't facilitating flight by holding her. He guessed wrong because the Court of Appeals said this is obviously facilitating robbery. Well, if that's correct, if it's facilitating robbery, like the Court of Appeals says is obvious, defense counsel guessed wrong. And I think he guessed wrong because he was never given this theory in the charging document. It was never set forth in the instructions. This court still can't know what the theory of the case is on appeal. And I think that's a ship without a rudder. I think it's a problem.
Thank you, counsel. What are you asking us to do?
Reverse the kidnapping, Your Honor.
All right. Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.